Hello, my name is Karen Dietrich, and I am the Director of the Office of International Affairs at the PCAOB. We are pleased to be able to provide this series of videos to provide an overview of the PCAOB, its oversight mandate, and activities for non-U.S. firms who are registered or who may be considering registration with the PCAOB. The views I express are in my official capacity as Director of the Office of International Affairs, but are my own and do not necessarily reflect the views of the board members, or other members of the board staff. The PCAOB's mission is to oversee the audits of public companies and of broker-dealers in order to protect the interests of investors and further the public interest in the preparation of informative, accurate, and independent audit reports. But before giving you a high-level overview of how the PCAOB works to achieve its mission, I will set the stage by providing some background on when, how, and why the PCAOB was created. The PCAOB was established by U.S. federal law, the Sarbanes-Oxley Act of 2002. Prior to this law, auditing was a self-regulating profession. The Sarbanes-Oxley Act was passed after the discovery of financial reporting and auditing improprieties at numerous public companies in 2001 and 2002, including Enron and WorldCom, which resulted in a national crisis in confidence in the integrity and reliability of public companies' financial statements. For example, on July 15, 2002, WorldCom announced an overstatement in cash flow of over $3.8 billion and subsequently filed for bankruptcy, surpassing Enron as the largest bankruptcy in U.S. history. After this, investors, regulators, and the U.S. Congress believed there was a need to bolster internal control over financial reporting and bring an enhanced focus to corporate governance. The creation of the PCAOB reflected a view by the U.S. Congress that peer review had not been effective. The Sarbanes-Oxley Act applies to two categories of entities. The first is all public companies, which are companies, whether located in the United States or elsewhere, that are issuers of securities as defined by U.S. securities laws. And the second is all audit firms, regardless of where they are located, that prepare audit reports for such issuers. Title I of the Sarbanes-Oxley Act establishes the PCAOB and contains key provisions, including the PCAOB's duties regarding audit firm registration, standard setting, inspections, investigations, and disciplinary proceedings, authorizing oversight by the PCAOB by the U.S. Securities and Exchange Commission, and requiring audit firms, including those located outside of the United States, to register with the PCAOB before they may prepare or play a substantial role in preparing an audit report with respect to any issuer. The bottom line is that a firm's audit work for a U.S. issuer is the basis for PCAOB jurisdiction over the firm, no matter where the firm or issuer are located. In 2010, the Sarbanes-Oxley Act was amended by a law known as the Dodd-Frank Act to give the PCAOB oversight over audits of SEC-registered broker-dealers and the authority to share confidential information with foreign audit oversight authorities. Before the Dodd-Frank Act, the PCAOB was unable to share with its foreign counterparts any information related to or obtained in connection with inspections and investigations, including when those inspections or investigations were conducted in other countries and involved firms subject to the oversight of a home country audit regulator. After seeking and being granted the authority to share such information, the PCAOB was able to enter into bilateral cooperative arrangements that allow our inspectors and investigators to work with and share information with non-U.S. regulators who have oversight responsibilities over firms located in their jurisdictions that are being inspected or investigated by the PCAOB. The PCAOB is governed by a 5-member board, all of whom must be independent from the audit profession. While 2 of the 5 board members must be certified public accountants, also known as CPAs, these CPAs also must meet the independence requirements. The PCAOB is subject to the oversight of the U.S. Securities and Exchange Commission, which appoints PCAOB board members, approves the PCAOB budget, and approves rules and standards adopted by the PCAOB. The largest source of funding for the PCAOB comes from the companies whose financial statements must be audited by PCAOB registered firms. This is known as the accounting support fee. A public company's annual support fee is calculated based on market capitalization, while a broker-dealer's annual support fee is calculated based on tentative net capital. Firms also pay a registration fee and annual fees, but the vast majority of the PCAOB's funding comes from the public companies and broker-dealers whose audits are under the PCAOB's oversight. The PCAOB has a number of core areas of responsibility. These are registration of audit firms, inspections, investigations and enforcement, and setting professional standards. In support of its mission and its core areas of responsibility, the PCAOB also conducts economic research and risk analysis and engages with PCAOB stakeholders and with audit regulators from non-US jurisdictions, among other functions. I will provide a high-level overview of these functions, but other sessions will go into more detail. As I noted earlier, public accounting firms must register with the PCAOB in order to prepare or issue an audit report for a U.S. public company or an SEC-registered broker-dealer, or to play a substantial role in those audits. The term play a substantial role is defined in PCAOB rules and relates to the materiality of the work provided by the firm to the auditor signing the audit opinion, including in terms of audit hours or fees, or the percentage of the assets or revenues of the consolidated entity. Registration is the process by which the PCAOB establishes oversight authority over public accounting firms. Once registered, firms have certain obligations to comply with PCAOB rules and requirements. A firm's registration application contains important information about the firm and its partners and staff. It also includes the firm's consent to cooperate with the board and an agreement to secure and enforce similar consents from its associated persons in order to maintain its continuing registration with the board. PCAOB Rule 2105 makes an allowance for non-US firms to withhold certain information in the registration process if providing that information would be an actual conflict with their local laws as supported by a legal opinion to that effect. However, I should point out that this rule does not allow firms to withhold information from the PCAOB in the context of an inspection or investigation. And any legal conflicts that arise in inspections or investigations have to be resolved, often through consents from the audit firm, its staff, or its audit clients. I will talk more later about this obligation for firms to provide full access to PCAOB inspectors and investigators, but that is an important point for firms to understand before they take on audit work for U.S. issuer clients. Firms also have certain obligations under PCAOB rules to file periodic reports with the PCAOB. Each year, firms must file an annual report and pay an annual fee. In addition, firms may have to file special reports upon the occurrence of a variety of events and to file a Form AP when they issue an audit report. Failure to meet these requirements may subject firms to disciplinary actions. Withdrawing from PCAOB registration also requires the filing of a form, known as the WD-1 form, but the PCAOB has the right to delay such a withdrawal, for example, if an inspection or investigation of the firm is pending at the time. Once registered, a firm that performs audit work under the PCAOB's authority, that is, audit work on a U.S. issuer or broker-dealer, also has to meet certain obligations. First and foremost, auditors must comply with relevant standards and rules. For U.S. issuer audits, that means firm must comply with PCAOB quality control standards and perform their audit procedures according to PCAOB auditing standards, as well as the independence rules of the PCAOB and U.S. SEC. I should note that the PCAOB recently issued a new quality control standard, QC 1000, that firms should familiarize themselves with. And to assist with that, the PCAOB has posted extensive implementation guidance, including documents and videos, on its website. Notably, this standard requires all PCAOB registered firms to design a quality control system that meets the requirements of the new quality control standard, regardless of whether they are currently performing audit work for U.S. issuer or broker-dealer clients. Firms will be required to implement and operate the QC system in compliance with QC 1000 when they lead an engagement under PCAOB standards, play a substantial role in the preparation or furnishing of an audit report, or otherwise have current responsibilities under applicable professional and legal requirements regarding any such engagement. In addition, once registered, firms are subject to PCAOB inspection and, where appropriate, investigations. Firms that regularly issue audit reports for issuers are subject to inspection by the PCAOB at least every 3 years, or annually if the firm issues more than 100 audit reports each year. Each year, the PCAOB also inspects some firms that do not issue any audit reports, but who play a substantial role in one or more issuer audits. Finally, the PCAOB may conduct an investigation of any act or practice or omission to act by a registered firm and its associated persons, and may potentially sanction them for failure to follow the Sarbanes-Oxley Act, PCAOB standards, PCAOB rules, and SEC rules applicable to auditors. The PCAOB also establishes or adopts auditing and related attestation, quality control, ethics, and independence standards. External input is important to the board's development of standards, and the board seeks such input in a number of ways, including public notice and comment periods, meetings of the PCAOB Standards and Emerging Issues Advisory Group, and the PCAOB's Investor Advisory Group, as well as ad hoc task forces and forums such as roundtables on selected issues. And last but not least, all standards adopted by the PCAOB are subject to SEC approval. Again, there's extensive information on the PCAOB website about PCAOB standards and rules, including guidance about implementation and reports discussing findings from inspections that may assist firms in complying with applicable PCAOB standards and rules. Turning now to inspections. A PCAOB inspection is designed to assess the firm's compliance with PCAOB standards and rules, as well as other regulatory and professional requirements that are applicable to the firm's system of quality control and to the portions of audit selected for review. A PCAOB inspection is not designed to review all aspects of a firm's quality control system, to review all of the firm's audits, or to identify every deficiency in the reviewed audits. Inspections result in individual reports issued to each firm, portions of which are made public, and firms have certain opportunities to respond to inspection findings and remediate any identified deficiencies and defects in their quality control systems. More detail about inspections will be provided in the inspection session of this overview program. In terms of enforcement and investigations, the PCAOB also investigates potential violations by public accounting firms and their associated persons and may discipline such firms and their associated persons for violations of laws, rules, or professional standards. Investigations can stem from various sources, including inspections, public information, and tips. The Division of Enforcement Investigation can review auditors to produce documents and information and can take testimony from auditors. If disciplinary charges are recommended, they are communicated to the firm and/or individuals who also have an opportunity to respond by providing a statement of position on the subject of the investigation. If disciplinary charges are brought, firms or individuals may choose to make an offer of settlement to the PCAOB, which is subject to board approval. If the parties do not elect to settle, hearings are conducted by the PCAOB hearing officer to determine whether firms or associated persons committed violations and should be sanctioned. Any sanctions imposed by the hearing officer can be appealed to the board, the SEC, and then the federal courts. Again, you will have the opportunity to learn more about the enforcement process in a separate session provided as part of this overview program. I would also like to highlight for non-U.S. firms the strong confidentiality provisions for information provided to the PCAOB as part of an inspection or investigation. Section 105 of the Sarbanes-Oxley Act protects all documents and information prepared or received by the board and deliberations of the board and its employees and agents in connection with an inspection or investigation. It requires that such material, including information provided by a firm, must be kept confidential and privileged as an evidentiary matter. Thus, the information is expressly excluded from civil discovery or other legal process by a court or administrative agency. The law also expressly exempts such material from disclosure by U.S. agencies under federal records request or sunshine laws. One common theme you may have observed throughout this discussion is my emphasis on the point that non-U.S. firms are subject to the same requirements as U.S. firms in terms of applicable laws, rules, and standards, registration and reporting obligations, and being subject to inspections and investigations. That said, the PCAOB early on in its existence articulated that it would adopt a cooperative approach regarding the oversight of non-U.S. firms, including by working with non-U.S. regulators on inspections, investigations, and to resolve conflicts of laws. To do so, the board often seeks written bilateral arrangements with non-U.S. audit regulators in order to help facilitate access to information needed for PCAOB inspections and investigations. But ultimately, each firm remains responsible for providing full and complete access to information requested during inspections or investigations. This is an important topic, so I would like to say a few more words about the requirement that firms must provide full and complete access to information required for a PCAOB inspection or investigation. PCAOB Rule 4006 requires that firms cooperate and comply with any request made in connection with an inspection to provide access to and the ability to copy any record in the possession, custody, or control of such firm or person, and provide information by oral interviews, written responses, or otherwise. Likewise, for investigations, PCAOB Rule 5110 allows the PCAOB to impose sanctions against firms for their failure to cooperate by complying with PCAOB requests for testimony and documents. Under these and other applicable standards and rules, it is also not permissible to make modifications of archived audit work papers in advance of an inspection or investigations other than as explicitly permitted by PCAOB standards, and doing so may subject firms to disciplinary action. I mentioned a little earlier the strength of the confidentiality protections required by Sarbanes-Oxley Act's Section 105. And we find that these protections are often deemed by firms and non-U.S. regulators to satisfy home country professional secrecy and other confidentiality requirements when providing information to the PCAOB during an inspection or investigation. If necessary, firms are responsible for seeking any consents that may be needed from their staff or their issuer clients. I noted earlier that firms may wish to consider these obligations before they register with the PCAOB or before they decide to take on U.S. issuer clients. Indeed, the PCAOB has on its website a document with PCAOB staff answers to frequently asked questions related to registration by non-U.S. firms. That document states in Q&A number 4, a registered firm's failure to cooperate with board requests for information may subject the firm to disciplinary sanctions, including substantial civil money penalties and revocation of the firm's registration. In the staff's view, if a firm fails to cooperate with the board, the fact that the firm has not obtained a client consent that might be necessary under non-U.S. law to allow the firm to cooperate is not a defense to a disciplinary action for failure to cooperate. As a practical matter, therefore, a firm must choose whether, 1, to satisfy itself in advance that the non-U.S. client will provide any necessary consent if and when the board demands documents or information concerning the client, 2, to proceed without such assurance and take a risk that it may later have to choose between providing information without the client's consent or facing a board sanction for failing to provide the information, or 3, to decline the audit engagement. While the PCAOB has taken a cooperative approach to working through potential conflicts that may impact a firm's ability to provide information, the U.S. Congress has clearly articulated that the PCAOB must be able to inspect or investigate completely. A law passed in 2020 called the Holding Foreign Companies Accountable Act, or HFCAA, requires the PCAOB to consider whether any inability to inspect or investigate completely a foreign registered public accounting firm is due to a position taken by one or more authorities in a foreign jurisdiction. If the board makes a determination under the HFCAA that it is unable to inspect or investigate completely because of a position taken by a foreign authority, the SEC will require covered issuers who retain registered firms located in the applicable foreign jurisdiction to make certain disclosures in their annual reports. And eventually, if certain conditions persist, the SEC will prohibit trading in those issuer securities on U.S. exchanges. PCAOB Rule 6100 implements the HFCAA and sets forth, among other things, the factors used by the board in making this determination. Under this rule, the board will assess whether the position taken by the foreign authority impairs the board's ability to execute its statutory mandate with respect to investigations or inspections of such firms in one or more of the following respects. 1, the board's ability to select engagements, audit areas, and potential violations to be reviewed or investigated. 2, the board's timely access to and the ability to retain and use any document or information, including through conducting interviews and testimony, in the possession, custody, or control of the firm or any associated persons that the board considers relevant to an inspection or investigation. And 3, the board's ability to conduct inspections and investigations in a manner consistent with the provisions of the Act and the rules of the board. These requirements underscore the importance of firms providing to the PCAOB full access to information and inspections and investigations, and it is important that firms work through potential legal conflicts with the PCAOB and their home country regulator such that the consequences of both non-cooperation rules and the HFCAA can be avoided. Let me turn briefly now to how the PCAOB works cooperatively with its non-US regulatory counterparts, not just to address legal conflicts, but also to reduce the burden of inspections and investigations on firms. In some jurisdictions, the PCAOB and the local regulator conduct inspections jointly, and in some investigations, the PCAOB's enforcement staff will work with home country regulators in conducting parallel investigations that also involve the sharing of information in joint meetings with firms or firm counsel. The degree of interaction with the home country regulator varies due to multiple factors, including the legal requirements in the non-US jurisdiction and whether bilateral arrangements are in place to allow for the sharing of confidential information. In our experience, bilateral agreements can facilitate sharing of confidential information and provide a framework for resolving conflicts of law, including, where applicable, personal data protection laws. Delving a bit deeper into inspection, some examples of the coordination that my office, the Office of International Affairs, helps to facilitate during joint inspections include planning inspection logistics, such as coordinating inspection schedules and determining whether PCAOB inspectors and those of the home country regulator will be in the field at the same time, developing plans for communications with the firm and among the two regulators throughout the process, establishing a regular dialogue during inspections, including to discuss each regulator's potential inspection findings, and facilitating the exchange of information, including findings and documents, both during and after inspection fieldwork is completed. The most extensive form of interaction is a joint inspection with the PCAOB and home country regulators inspectors in the field at the same time, and in some cases, working closely together in reviewing materials, interviewing firm staff, and discussing potential findings. PCAOB rules also permit the PCAOB to rely to some degree on the inspection work conducted by a home country regulator. PCAOB Rule 4012 allows reliance, to the extent deemed appropriate by the board, on the inspections work of a home country regulator. A number of factors inform whether the board may rely on a home country regulator's inspection, and if so, to what extent. These include the independence and rigor of the home country system of audit oversight and discussions between the PCAOB and the home country regulator on inspections programs. The board's evaluation for purposes of reliance is not a mechanical exercise of checking boxes. The PCAOB examines the structure and operations of the home country regulator system as a whole and frequently has extensive discussions with the home country regulator's inspectors to determine the appropriate degree of reliance for a given inspection. And even in connection with such reliance, the inspection work by the non-US regulator must include review for compliance with applicable US standards and rules. Finally, before I wrap up, just a few words about cooperation in enforcement matters. Where authorized by a statement of protocol or other bilateral agreement, OIA helps facilitate the PCAOB Enforcement Division's coordination with foreign counterparts in cases involving non-US audit firms or associated persons. The relevant agreements often facilitate the PCAOB's evidence gathering in foreign jurisdictions, may result in PCAOB staff briefing the home country regulator on the PCAOB's ongoing investigative activities and findings, and in some cases result in parallel investigations and potentially simultaneous sanctions by the PCAOB and its non-U.S. counterpart. You will hear more about the PCAOB's activities, including inspections and enforcement, in the other sessions of this overview program. I hope that you find the information helpful, and we are interested in your feedback. You can contact the PCAOB's Office of International Affairs through the PCAOB website. Thank you for your attention.